Good morning.
Your Honor, unfortunately, I feel that this is essentially a waste of the court's time here. And the proper course of action would essentially be for Ms. Owens' office to recuse themselves from the case, specifically because she was more than just present during this investigation or this traffic stop. As noted in the state's motion, Your Honor, Category A witness is an eyewitness, alibi witness, or rebuttal witness present when recorded statements were given. Witnesses known to have material information that negates guilt. All of these apply to Ms. Owens. Specifically, Your Honor, she is a material witness who not only participated on scene by observing and instructing the officers, but she essentially dictated what the officers were doing on scene.
She said she wasn't at the scene.
I've got a video for the court. I don't think she was.
I did respond to the scene, Your Honor, after the individuals from the vehicle had been detained.
Oh, okay. I got you. All right, go ahead.
So the court is aware, around 4:30 p.m., there was a traffic stop. Shortly thereafter, pre-arrest, when 3 of the occupants were seized in a vehicle, Ms. Owens arrived on scene. She was present on scene for at least 2 hours pre-arrest. The officers testified that they did not advise Mr. Jones he was arrested until 8 p.m. plus at night. So essentially 4.5 hours where Ms. Owens is on scene, instructing these detectives what to do. Essentially, there's conversations on the videos where the officers are advising to take property, personal property of Mr. Jones and the occupants, and to put it into his property to be returned to him. The video then shows Ms. Owens coming up to these officers, advising them that they need to seize all of these phones because they're evidence of a crime. However, nobody has been arrested at this point. She further goes on to instruct them that all of the evidence or all of the property in the vehicle, which noted nothing illegal was found in the vehicle, was all evidence of a crime. And there was no search warrant at this point in time. So after instructing the officers what to seize, what to take possession of, she continues to meet with these officers for hours on scene, discussing how they're going to go about this investigation. Proceeds to follow the patrol vehicles, or they follow her to the state attorney's office, where again, she participates in a recorded interview with Mr. Jones for 2 hours. Your Honor, the very definition of a material witness, she meets all of those requirements. She certainly is material in this case. I'm honestly shocked that we're even having to go through this based on the body worn cameras that clearly show her role in this. In addition, not only is she instructing these officers, within 25 minutes of the traffic stop, she can be seen on video searching the passenger side of the vehicle, the back passenger side of the vehicle, going around to the driver's side of the vehicle, looking inside, then the back passenger driver's side of the vehicle, as well as pointing to cell phones, talking to the officers about whose cell phones is what. And despite one of the 3 occupants being arrested, all of the occupants' cell phones were seized at Ms. Owens' instruction. Clearly, she's relevant to this case. More importantly, Your Honor, during depositions, 7 officers, all of who were present, or however many gang officers there were present, unequivocally testified that none of them made the decision as to what was being taken as evidence. In fact, Officer Ferrari and several others had confirmed that they were instructed to place this in personal property, but it was Ms. Owens who then came up to him and said, no, that is not personal property, it's going into evidence. These decisions of the investigation were made by Ms. Owens on scene, and it's clearly depicted on the body worn cameras. Whether she was present or not for the traffic stop, as the court will see in future hearings, I anticipate, he never failed to stop in the first place, Your Honor. So the fact that she was on scene of a civil traffic stop, which they claim was a felony takedown, for 2.5 hours and investigated this for 4.5 hours before an arrest took place, clearly shows that she's not prosecuting at that point in time. She is a material witness that I do intend to call. I did try to depose her. She was subpoenaed, and the deposition was scheduled to take place last week. There were 3 witnesses scheduled that day. 2, Ms. Owens was present for the first 2, and then when her deposition came around, she walked out of the room saying she would not be deposed. My client certainly is entitled to some of the information that she has.
And that's the basis of your motion to hold her in contempt.
Yes, Your Honor, correct.
Right. That one can be easily resolved. I'm going to circle back to the ones that y'all are bringing before me today. That one's easily resolved because I think, as you know, I would assume you know, Mr. Fusco, the rule of procedure that deals with taking depositions provides that you can take the deposition of the party opponent that's listed as a category A witness. So if, in this case, the state of Florida lists a witness as a category A witness, you're entitled to depose the witness. If they're not a category A witness, you can only depose them with leave of the court. So there's no basis for an order to show cause under that scenario. So that's easily resolved. But anything else on the motion that we're actually here on today?
Your Honor, I would just further state that the material witness, as it states in case law, is one who gives testimony going to some fact affecting the merits of the cause about which no other witness can testify. Clearly, no other witness has knowledge of some of these decisions that Ms. Owens made, and it's only her who possesses this knowledge. Anybody that may have knowledge would be hearsay. So I certainly would like to hear from Ms. Owens as to why these decisions were made before an arrest took place.
Question.
Yes, sir.
Your Honor, I do think it would help to clarify for the record that just like a homicide scene, every single homicide case I have, I was present at the scene. I did not search anything, did not put gloves on, did not touch any item in that vehicle. I just looked inside of the vehicle and around. So I don't know if we're extending the definition of search to looking inside.
All I heard was you searched. That's what I'm going on.
I do want to clarify, and just because I have maybe a moment, I was never in the interview room. So participating in the interview.
I wrote it. I'm glad you brought that up because that was one of my questions about when you said, Mr. Fusco, that she participated in the interview. Did she participate in the actual discussion with your client? Directly? I know it's a term of art, for lack of a better term, but tell me what you're saying Ms. Owens did.
Yes, sir. So on the actual interrogation video, I did not personally see her in the room. It does show on the body camera where she's outside conversing, where the officers come and go and meet with her, things of that nature. I did not see her personally in that room. The big thing, Your Honor, is as Ms. Owens has stated, it is common for prosecutors to come to the scene of a crime, a homicide, and investigate a crime that has taken place. This was not yet any criminal offense, in my opinion. The officers clearly stated and told Mr. Jones for 2.5 hours, this is a routine traffic stop. We're going to give you a ride home. They then tell him they're taking him to the state attorney's office to question him about one of his best friend's murders. He's still not under arrest. It's my belief, Your Honor, from watching videos that had Ms. Owens not arrived on scene, I don't know if these officers would have made an arrest. They clearly did not place him under arrest until that decision seemed to be made by Ms. Owens, at which point they effectuated the arrest.
So what is it? Same question that I asked Ms. Owens. What do you want me to do today?
Your Honor, I think that giving us an opportunity to see what Ms. Owens' role was by at least taking a deposition, whether she's listed as a witness or not, she certainly is going to be involved in the defense because she is all over the body on cameras and made a lot of decisions in this case. I don't know, this isn't for this hearing today, but at no point did he flee. I mean, rolling 300 feet to a stop. It's kind of ridiculous at this point, Your Honor.
All right, I got your concerns. I just need to know what it is that you want me to do. So you want me to authorize you to take Ms. Owens' deposition?
Yes, Your Honor. If need be, list her as a witness to defend Mr. Jones against this charge.
Okay, anything else you're asking me to do today?
Nothing as it relates to this issue, Your Honor. No, sir.
All right, so, and I hearken back to pretty much the first thing I said when we started the hearing, which was that I have read the materials and did not see any case law that was cited. You're a very bright lawyer, and I'm sure you're aware that this is not the first time that courts have been asked to do what you're asking me to do here today. Do you have, so I cannot imagine that this is a case of first impression. I have done no research in preparation for this hearing because that's y'all's job. So what, if any, case law do you have that supports your position and what you're asking me to do here today?
Your Honor, there's been a lot of case law that I've seen for perjury charges and things of that nature. Nothing specifically related to this, and I would just defer to the rules of discovery and what.
Are you telling me, I'm sorry to interrupt you, but are you telling the court that there is no case law in the state of Florida, not in the far-flung lands that Ms. Owens referred to and other judicial systems, but in the state of Florida, that deals with the issue of the defense in a criminal case, wishing to either recuse the state attorney's office, which you mentioned earlier, although you didn't indicate that that's the remedy that you're seeking today, or in seeking to depose the sitting prosecutor on that criminal case? Is that what you're telling me, Mr. Fusco?
No, sir. There are cases where that has been permitted. It's been different situations, different circumstances. They're factually different from this one. I can certainly pull some for the court. I just, to be honest, didn't think it would be necessary based on just the rules of discovery in the video in and of itself, but I will provide some, Your Honor.
Okay, well, I'll certainly give you an opportunity to do that, because I will tell you that the court disagrees with your interpretation of the rules of criminal procedure. As I've already indicated on at least one issue here this morning. But in any event, I'll certainly give you the opportunity to supplement your request to the court with case law, and the same for the state, because I didn't see anything cited by the state either. I know that you had cited a case dealing with the generic discovery responses, but that's not really applicable here today. So if both sides wish to avail themselves of the opportunity that the court is giving them to supply case law to the court, I'll certainly do that. How much time do you think you would need to do that?
I'll get it to the court this week. I'm in a wrongful death trial starting next week, so I'll get on that today as soon as possible.
Okay, Ms. Owens.
That sounds reasonable, Your Honor.
So when do y'all want to come back?
Any date works for the state.
Whatever's best for the court.
Well, you said when are you starting your trial?
Jury selection's on Monday, Your Honor, and it goes till the 19th, 11th through the 19th.
And that just the jury selection or the trial?
Maybe a pick and go. We still have so many issues to iron out, Judge Dees and scheduling. We'll find out, I think, a lot more this afternoon.
Okay. Madam Clerk, can you move your paper there? Because I'm looking at August here. Sorry. You want to come back the week of August 1st? You think you'd be done by then?
Yes, sir. That's perfect. I believe we do have court on this case on August 1st. So that's,
Oh, do we?
yes, sir.
Where's my sheet here? Okay, well, let's do that then. Let's come back August 1st and I'll give when did you say you'd have the case law by the end of the week? Because I'd like to come back on the 1st for ruling on the motion is what I prefer to do.
Yes, sir. Ideally, honestly, I'll try to get into the court today or tomorrow as soon as possible. I've done a lot of research on the issue, so.
Okay, well then I'll give the parties to the end of the week to, actually, I'm going to give you to the end of next week. There's no big hurry on it since we're not coming back to the 1st. So any additional materials will be supplied to the court no later than July the 14th. And then we'll come back August 1st for ruling on the motion and then hearing on the motion to be set that week on any additional matters. I know there's some other pending, which, as you said, may flow from the courts, whatever the court's ruling is on this one. And Mr. Fusco, I note that speedy trial is scheduled to run September 27th. Doesn't matter to the court what you do with that, but have a discussion with your client, and depending on what you decide to do on that issue, will determine whether or not the court sets the case for trial relatively quickly on that August 1st date.
Yes, sir.
Anything else from the state?
No, sir.
Defense?
The only thing remaining, Your Honor, is the statement of particulars. We filed that motion back in May. The state had mentioned they were going to respond, and we still yet to receive a response.
State?
Yes, sir.
When are you going to respond? Huh?
I will respond.
When?
When? Respond today.
Okay, she's gonna respond today, allegedly. All right, no, try to get it done by today or the end of the week. Okay, anything else?
Nothing from the defense, Your Honor.
All right, thank you both,
Thank you.
and we'll see you on August 1st. Court will be in recess until, is it 1:30 or 2? We have our sentencing, 1:30? All right, 1:30.